here today. We're excited to talk about this great movement for the cause of all payer claims databases and for the use of healthcare data. Just as a reminder, I think everybody has done this enough now that you know it's best if you all keep yourselves on mute, especially there's 215 of us on the call, so that would be kind of noisy if we had just the background noise, but we're welcome. And we have on call today, we have guest presenters. I'm going to just run through the agenda. So I will give welcome and introductions. Then we have Joe Porter from the University of New Hampshire Institute for Health Policy and Practice, who will be telling us about some of the history behind how we got to where we are today. Then I will run through the provisions of Section 115. And we've asked John Friedman from Friedman Healthcare to give us his reaction and to moderate a kind of a Q&A discussion of that one. But we want to make sure that we leave time at the end to have a group discussion as to what's our plan for moving forward. What are we going to do about this, and how are we going to stay in touch, and what's going to happen, and those sorts of things. So again, for those of you who just barely joined, my name is Norm Thurston. I'm the Executive Director here at NAHDO, and I'm also a co-chair of the APCD Council. So NAHDO is a national nonprofit membership and educational association, and our main focus is on improving healthcare data collection and use. That's what we do. We've been doing it since 1986, been around for a very long time, and have been involved in a lot of health data efforts, including hospital data, APCDs, and a lot of other things as well. And we invite you to learn more about us on our website. We recognize some familiar faces here, but we also see a lot of names of people that we have probably not had the pleasure to meet in person before. On our website, there are a few things that I would just draw to your attention. One is that you can register on the main page to be on our email list and receive our newsletters. We send out a newsletter about the 15th of the month, every month. And if you're not on that newsletter list, we would encourage you to sign up for that. There will be information flowing out about this topic through the newsletter and other things as well. We also have information about our current members, our partners, and benefits. Some of you might want to consider joining NAHDO as a member. I'm not making this into a sales pitch today, but if that's something that is up your alley, feel free to take a look at that. We also have some follow-up from today's conversation. We've preloaded onto the website under the resources tab. There's some information from today's webinar that's been preloaded onto the website. You can take a look at that. This webinar will also be loaded up there so that you can get information. If there's something that you wanted to see in more detail and missed, you can do that as well at the website. And I mentioned earlier the APCD Council. So Joe Porter, who's on the call with us today, Joe and I are the co-chairs of the APCD Council. The APCD Council is a learning collaborative, and it's been around for about almost 10 years now, I believe. I can't keep track of anniversaries very well. And Joe, are you able to take yourself off mute?
I think so.
Okay, great. Yes. Okay. So we're here together to talk to you briefly about the APCD Council. It is a joint project of NAHDO and the Institute for Health Policy and Practice at the University of New Hampshire. And I want to give Joe just a minute to kind of give you a history of the APCD Council and then segue into a discussion of the history of our joint efforts between NAHDO and the University of New Hampshire through the APCD Council on this issue that has led us to where we are today, which is the federal No Surprises Act. Joe, go ahead.
Great. Do you want to switch over our slides, Norm?
I'm just going to go scroll right to the next one. That
okay. One? Still sitting on the About Us, but I think the work that we've done, so I'm probably a little bit better with the anniversary. So we've been around for actually 15 years, getting this work together. And our history has included a lot of catalyzing states to achieve mutual goals. So we had history way back in a long time ago, folks may remember who've been doing this for a while, where there was a common interest in Medicare data as a big gap for states. And we did a tremendous amount of advocacy work at the federal level to try to solve for that, that issue. And very similar, we've been advocating for solving for a number of data gaps for states in recent years. And this work and this Section 115 that we see in this bill we feel is pretty tied to some of that advocacy work that we've been doing for several years. So this is a selected set of advocacy responses for federal activity. This is not inclusive of everything that we've been working on, but certainly the things that we think led to where we are today. And, you know, I think we were all fairly surprised to see the state APCD language in this omnibus bill at the end of 2020, but not completely surprised given the amount of activity that's been going on around this. So as folks know, in 2016, Gobey versus Liberty Mutual happened that caused some changes in what states could require for data submissions from ERISA-covered self-funded plans. In that same year, there was the very first kind of movement on the Department of Labor to indicate that they may be willing to try to solve for that issue, as was indicated in the Supreme Court decision around Gobey versus Liberty Mutual, which was very clear that they felt that the justices felt as though the Department of Labor had authority in this area. As part of that call for and the notice for proposed rulemaking from the Department of Labor around this Form 550 and Schedule J, one of the things that they called on significantly was this need for reduced burden and commonality in state data submissions. So this group of folks, many states, led at that point by the APCD Council, and Amy Costello, who is on this call, I think, was with the CDL development then and remains with it now. But there was a series of meetings that happened to develop this common data layout as we see it today. That continued in 2017, along with continued outreach to the Department of Labor. And then in 2018, we started to really see some activity that harkens itself to where we are today. So there was a Healthcare Transparency Initiative invitation for comment from a bipartisan Senate group that started to talk about the need for better data for transparency and a drive from the Senate leadership to make that happen. We submitted comments to that. And then we also saw our Protecting Patients from Surprise Medical Bills Act that we put comments out to, and meanwhile continued to work on the CDL. And then in 2019, the Senate Help Committee pulled together some inquiries, had some inquiries to us in the beginning of 2019, really digging into some of the state APCD activity. And then we saw the Lower Healthcare Costs Act come out later that year that seemed pretty reflective of some of that advocacy work that we had been doing, which we were pretty pleased about, although it wasn't exactly every parameter that we had hoped for in the way that we had hoped for it. And then in 2020, there continued to be work around the Lower Healthcare Costs Act. And then there were a few other bills that came out with some of the parameters that were in Lower Healthcare Costs Act, but separated from the larger bill, which was pretty comprehensive, including this Transparency and Accountability in Healthcare Costs and Prices Act. And there were parameters around state APCDs in both of those pieces of legislation, and some of those seem to survive and end up as Section 115 of the Consolidated Appropriations Act. And as Norm will talk about in depth around what's contained in that act, certainly there is a push in there for this common standardized layouts for data submission. And so the work that's happening now, thank you all to all of the folks who've been engaged in it on the APCD CDL, I think is going to be relevant in that conversation. So again, you know, we were pretty surprised to see the state APCD language land in this omnibus bill, but not all that surprised to see the language having seen the derivations of prior legislation that were reflected in this piece. And I will turn it over to you, Norm.
Think you're on mute, Norm.
There we go. Thanks for catching that. Yes, so thank you, Joe. We understand that there's some of you who may not be able to see the slides for some reason. Charles and I are working on getting those uploaded to the NAHDO.org website. We'll have those up in probably just maybe another 2 minutes or so. So if you want to just check there in a couple of minutes, you'll be able to see the slides. Give me 1 second. All right. So what's in this bill? I'm going to try to give you this is not an interpretation. I don't want to get into interpretation. I will point out some areas where there's some interpretation needed, but I think we can fairly confidently read this bill and understand most of what's in it. So the first set of things that we want to talk about are in subsection A, which subsection A relates to the Department of Health and Human Services. The big thing here, and probably what got most of your attention, is the idea that there would be a grant program. So the bill clearly says that grants will be given to states to establish or improve a state all-player claims database. And the three things that I will point out right there that I will not interpret, maybe John can opine on this a little bit later, is what does establish mean, what does improve mean, and what is a state all-payer claims database? Definitions are kind of important when you're asking the federal government for money. So that's what it's there for. The eligibility is clear, though. It's based on an application that at least specifies how the state will collect, have uniform data collection, and ensure the privacy and security of the data that they're collecting. We don't know anything else yet at all of what they are planning to include in that application process. It could be just that simple, but as you applied for federal grant funding before, they could make it more complicated. It's not known. Grants, however, we do know will be for 3 years, $1 million each for the first 2 years, followed by $500,000 in the final year. So there is money, and there's plenty of money available for all the states to apply. So it's not going to be, should not be competitive. So should not view it that way. Expectations on authorized users. There is some language in here that says that entities that wishing to use the data from a grantee may, so the state has to allow you to submit a data request for an APCD funded under this program for research purposes, quality improvement, or for cost containment. Authorized users will be prohibited from attempting to re-identify and disclose protected data. And here's a couple of things that are new. One is that employers may request customized reports at cost. Again, no clarification as to what those reports would look like or what they would contain. And that grant-funded states shall make aggregate data publicly available free of charge. Again, we don't really know what that's going to look like. But I suspect, again, I'm going to break my rule. I'm going to suspect what I think that means. Many states right now publish on their websites comparison data on cost and quality. I think that is what they're hinting at. But again, we won't know until we see it. And of course, the Secretary of HHS may waive requirements if the state is substantially in compliance. There's also expectations on expanded access. The Secretary may prioritize applications, and don't know what prioritized applications means, that establish a single application for data from multiple states. So there's an incentive for states to work together, if at all possible. And there's also prioritization mentioned for states that plan on implementing the Secretary of Labor's standardized reporting format for self-funded data. So those are the requirements from the Health and Human Services aspect of it. Now let's switch over and talk about the Department of Labor. The Department of Labor is tasked with developing a standardized reporting format within 1 year of passage. So by the end of 2021, the Department of Labor is supposed to have in place and periodically update a standardized reporting format for the voluntary reporting of data to state APCDs by group health plans. So it is only going to be applicable to voluntary reporting. And there's a lot of opportunities for us to discuss what that means. And John will have some things to say about that in his presentation as well. But it's also important to note that the Secretary of Labor shall provide guidance to states on how to collect such data in a standardized format. The Department of Labor is required to conduct a consultation. There is a 15-person advisory committee established. The qualifications are that every member of that committee should fall into one of two categories. They should be either distinguished in health services research, economics, informatics, privacy and security, or state APCD governance. In other words, a subject matter expert related to APCDs, or they should be representative, representing organizations that are either likely to submit or use APCD data, organizations such as patient groups, group health plan sponsors, healthcare providers, insurers, or third-party administrators. So that's a fairly broad group of opportunities there for people who are representative. There's a mention of a 3-year staggered term or until the committee is sunsetted, whichever comes first. And there is a report that is due within 180 days from the passage of the act. So by early summer, that committee is supposed to have met, resolved, and reported back their recommendations. The composition of the committee, here are the 15 members. There are specific slots for almost all of the positions. The Secretary of Labor is supposed to appoint 9 members, 2 assistant secretaries, one each from Labor and Health and Human Services or their designee, and then in consultation with the Secretary of HHS, a committee chair, someone from various HHS agencies, and I put this in highlighted here, a representative of a state APCD. The Comptroller General, which is from the General Accountability Office, is to appoint 6 members representing employers, employee organizations, academic researchers, and consumer advocates. That's 4, plus 2 additional members that are not specified. GAO has already released their call for nominations. Nominations for one of the 6 GAO slots are due on January 27th, and that link is available on our website already. I want to point out, however, that there are a few issues that Joe and I had mentioned that we've been working on for years that are still not fully resolved. And these are the 3 kind of biggest ones. It's not fully resolved in this act that we will, in fact, get into state APCDs all ERISA data. Since the Go Bay decision, we have been trying to figure out a way of making that happen through the federal administration process. That is not resolved in this bill, but it puts us on a good pathway forward. This bill does not also resolve fully the question of proprietary data. What data is protected because it is a trade secret and what data is not protected. There is some language here to guide that, but it's not complete. And then finally, the development of a national or federal database. That is left unresolved. There's nothing in this bill that discusses that. There's language here about multi-state access, but there's nothing here to establish whether we will or we won't have a national database and how that would exist. So with that, I'm going to turn the time over to John Friedman to get his reactions and insights and also to lead us in a Q&A discussion. John, go ahead.
Thank you, Norm. Let me just pull up my slides here. And hopefully you're able to see this all right. I know there's some problem with the slides before. So anyway, thank you, Norm, for that introduction. Yeah, I mean, this is a really exciting bill, and I think it's going to be very interesting to see the way that it plays out. And as you point out, there are some very positive provisions, and there's a few question marks. Let's start. You talked about the timeline. This is a very aggressive timeline. So, we're obviously in the midst of a presidential transition. GAO, as you noted, has put out a call for nominations. But, the bill was signed into law just on the 27th of last month. And advisory nominations are going to be due. And the advisory committee is really supposed to be appointed by March 27th. And it's supposed to have a report out by June 27th. Now, again, I don't know whether or not this will actually be adhered to as a format, but that's an awfully accelerated timeline. I think a very exciting timeline and an opportunity to do some things quickly. But it means that these nominations are going to be very important, and I think the opportunity to get at this is really a remarkable one. So I think all of us on the call should be thinking about how best we can make sure that people are on this group that are experts in understanding claims data, claims adjudication processes from the payer perspective, and understand the complexities in that, and are the sort of folks who can work well in a rapidly moving multi-stakeholder process to make this come about. Again, those recommendations have to come out for June, and then Labor has only 6 more months to consider and publish its own set of formal format. That's really fast. As a separate track, because these are 2 separate provisions in the law, are the grants. And those are appropriated and allocated to the federal budget beginning October 1st of this year. So that would be the earliest that those funds could possibly be dispersed. And again, it's not clear whether they'll be able to actually be dispersed at that point, or if there will be a somewhat longer time frame around that process. But there's a lot of good news in this. So if you're a state APCD or a state that's contemplating creating an APCD, there's a bunch of things here that are really important. Number one is it's a significant amount of money. Now, this is not a complete amount of money to run your APCD for multiple years, but it will go a substantial way to help defray those costs. And it's a big help. So, your peers on this call who have already created APCDs, you understand what that initial process was like and how much this would help. And because it is allowed to go to states that already have an existing one and are making improvements, which is really undefined in the statute, it is literally, as Norm said, quote, improvement, unquote, you can probably claim that you're making any change, improving the data quality and changing your visualizations, expanding the breadth of data collection, et cetera, would qualify. So, I mean, this is a tremendous help. Also, this money is available to enough money for 50 states. Now, again, I'm not quite sure the definition of a state. I believe the definition of a state is states and the District of Columbia, but it basically means virtually everybody has funds available to them. There is also a path, not a solution, but as Norm said, a pathway to be able to get to a national standard format. There will be a standard once labor promulgates its format for a voluntary set of submissions from ERISA. There will be no compulsion. It does not undo GOBE. It does not explicitly state that states will be able to compel submission of that data. But once there is a common format, one of the principal objections of some of the Supreme Court justices in the GOBE decision will have become overcome. And it really opens up an avenue either for a different judicial approach or more likely an expanded legislative approach. The other things it can do is it may well become a de facto format for all the submissions. So the non-ERISA, but the fully insured plans that are not subject to federal ERISA preemption may then use the same thing. Now that's going to depend, in my opinion, on whether or not this national effort through the Department of Labor is a robust standard. I can imagine that Labor might put out a very skinny standard that will say something like, well, for voluntary submission, here's a very limited number of data that you must put in, and it's enough to meet the letter of the law, but not enough to actually help an all-payer claims database do the sort of analyses that are necessary for health policy purposes and transparency purposes. If that's the case, it will fail to serve as a national standard. However, if it is robust and if it in fact largely resembles the existing data submission guides of the 20-odd states that have got APCDs or in process, then I think there's a really good chance, because I think a lot of states are just going to say, we might as well just adapt to that, and states that are starting out will want to adopt that as well. Two of the most recent states that are going forward have largely announced that they will simply adopt the common layout, which essentially is 90% in common with all the other states and what they've already got. It can reduce the complexity. This is one of the big things for data submitters. The objection of Liberty Mutual in the GOBE case was that if they were subject to submitting to 50 states, they would have to use 50 different data formats. This now clears the way and makes it a lot easier for the health plans. That is should no longer be an objection from the perspective of health plans. And it can ease multi-state collaboration, not only because there's priority given to multi-state applications, but if there is adoption of a common national standard, it becomes much easier for states to do that. Unfortunately, as far as I know, there's only a single example of multi-state collaboration among APCDs, and that was the 3 northern New England states that did a series of work together. But there are a whole number of metropolitan areas that cross state boundaries, anywhere from very large metro areas like New York and Chicago, but down to a whole lot of mid-sized places that are on borders, Kansas City, St. Louis, Louisville, Kentucky, et cetera, Cincinnati. It makes it much more plausible, feasible, and helpful to be able to have really valuable cross-state sharing, benchmarking, and comparisons. But I think maybe the biggest news of all is just this general sense that the federal government has stood up, taken notice, and I think, frankly, to most of our surprise, took a very large step towards really saying that all payer claims databases operated by states and moving towards a national standard are, what is in line with federal policy. The advisory committee, I won't belabor it. Norm went through it, but there's going to be a variety of appointments that need to be made. The Comptroller General has released the process for GAO. We've not yet heard from Labor what their process will be, but I think we should stand by on that. And it raises some questions that I'll address here. So I'm going to try to preempt some of the Q&A by jumping on what were a bunch of questions that stood out to me and to Norm and Charles when we were preparing for this, as well as my colleagues at Friedman Healthcare. So let me address these to the degree that I can. And then after that, I think what I'd like to do is open up the floor to questions. So perhaps people can start entering questions in the chat, and maybe Charles, if I could ask you to sort of help collate them, I would appreciate that. So here's some important things, and again, I've divided it up by the two parts of this bill, the grant program and the standardized format. So under the grant format, when will the grant applications be made available? As I said earlier, it's possible that the funding could be released as soon as October 1st of this year, but I think it's really not known, and it's going to depend upon just what the process is going to be and how quickly the new administration will be able to make this process come about. So we hope that there'll be funds actually being released later this year, but perhaps not until 2022. They talk about prioritization, and there's priorities given to states that agree to trying to adhere to a standard. There's prioritization if it's a multi-state effort, et cetera. But if virtually every state that applies is going to be able to receive a grant, what does that actually mean? I'm not sure how important the prioritization really is. It may actually be largely irrelevant for states that are applying. But again, we'll have to wait and see what the application process looks like. What about data access requirements for voluntary APCDs? So is there going to be a distinction made between mandatory and voluntary APCDs? Many voluntary APCDs are under more restrictive data use agreements with their data submitters than a mandatory one may be, and they may or may not be able to comply with the requirements as set out in the legislation for what an APCD has to be able to do. The grant program requirements that they have to share the data, et cetera. Who's actually going to enforce that? What's going to be the mechanism for that? How will that play out? Again, that too, I think, is really not clear. This, I think, is a key one. How will it interact with existing Medicaid match funding? I think the answer to this is that it does not, that they are completely independent programs and have no interaction whatsoever. And I make that interpretation because there is no mention of it whatsoever in this bill. And concurrently, there have been some recent amendments to the rules on Medicaid match that seem to be expanding its reach. I think this is incredibly good news, especially with the fact that it will be at least many months, if not a year or more, until the funds from this new law become available. It may actually put an appropriate large incentive on trying to get folks to continue to pursue Medicaid match and the enhanced federal match that's possible there, up to 90% of costs. That's been very successful for a number of states in establishing or expanding their work. We talk about this common format, and the legislation refers specifically to the usual files that APCDs use: claims, pharmacy, dental, providers, and payers. But it's pretty obvious, and at least 3 states have already adopted additional data that needs to be brought in because we're in a changing world. And what about alternative payment models? So if there are alternative payments, how do you collect that? How do you collect capitation data? How do you collect data on quality bonuses? How do you collect data on encounters that may not be directly related to that? What exactly does that mean? So I think that's something that is definitely going to have to be in the future, but this law is silent on that. And I think we are going to need, whether legislated or not, some national standard on how we're going to collect these alternative payment data. Can it be funded by the grant dollars? Not clear. Perhaps. I think we're going to have to struggle with that one. And then let me pivot over to the standardized format. So how will labor go from this committee's reports, recommendations to the final thing? Is a rule required? It's not clear from this that they must issue a rule. It may be that they simply make an announcement. If they have to make a rule, obviously a rule has to go through a notice of proposed rulemaking. There will be a comment period and then a final rule, and then it will take effect. But the legislation seems to suggest that the format should take place almost immediately in 1 year after enactment. That is right at the end of 2021. So I think that's a little bit unclear to me, but probably some of the lawyers might be able to answer that question. And then the other one that's also peculiar is the committee. So the committee members, Norm noted, are appointed for 3-year terms. People can be replaced and they'll have rotating 3-year terms. But if the committee is supposed to finish its work in roughly 3 months' time, and the bill calls for them to be sunsetted after they finish their work, what does this really mean? I wonder if that's really just a stopgap, that in case this gets terribly delayed and this process takes not months but years, that at least there is a mechanism in place to ensure turnover and fresh members of the committee. But at least in my reading of this, that should never come to pass. And it is my fervent hope that we'll be able to move beyond it. By the way, it does appear from the law that once the committee has made its initial recommendations, it is not a standing committee. It does not continue to bring updates to the Department of Labor for annual updates. It is purely on labor to continue to do its annual updates, apparently without the advice or input of any of the committees. So anyway, so those are some of the things that came to my mind. You know, this is my contact information and a couple of my colleagues. We know quite a number of folks who are on the call and have spent the last decade plus working on different states who have been building out their all-payer claims databases. So we'll be eager to answer your questions. But for now, let me stop sharing my screen and I'd be happy to open it up to questions.
Can you just can you reshare your screen and go back to the one with all the questions on it? I just want to, there's a couple of things that I wanted to throw in on and see if maybe Joe may have a couple of insights on some of those as well. So if you can reshare that screen with the questions on it. There we go. Yeah, yeah. John did a great job of kind of guessing or prognosticating the intent of the federal government. What my overall comment to everybody is, with the change of administrations, a lot of these things are really hard to know because there will be 2 new secretaries. Secretary of Labor will be new. Secretary of Health and Human Services will be new. We don't know how much influence they will want to have from the top down. If it's the current career folk at those 2 agencies, we could maybe make a guess, but we have no way of knowing how much of that's going to play its way out. There was one question here in the APCD grant program. This question about the voluntary APCDs, it's not entirely clear to me if a state that has a voluntary APCD that is not established by the state government, if that can count or not count. And so that's one of the areas where we want to make sure that we have some input to that process. Joe, did you have any comments on any of these questions, things that you wanted to add thoughts to what John said?
Yeah, thanks, Norm. I appreciate it. Yeah, I mean, I think the idea of the voluntary ERISA submissions, there's a lot to be gleaned in that. And, you know, we know that when the 2016 NPRM happened, there was a real commitment at labor to do whatever labor had the ability to do to support state efforts. Our hope is that that maintains, and then there was a lot of changeover in labor right after that at the top level. You know, we are still hopeful that the mechanism by which there are multiple flavors of voluntary, and that's a pretty encompassing term. So we've seen success in some states, particularly right after the Gobet decision, when they thought that when states were feeling as though they could do opt-out voluntary submissions, that there was still a lot of preservation of data. So, you know, there's still an opportunity, I think, for voluntary to look a couple different ways, and that'll be the work that has to happen with labor. I think to Norm's point, we'll be watching really closely to see how the Department of Labor gets populated from a staffing standpoint going forward. But we do know that there was a lot of intent to be supportive in 2016, and I think now legislative support for that as well.
Yeah, looks like following the chat with Charles here, we've got about a half a dozen questions or so. I'm going to pick a couple of easy ones and then let you all discuss the harder ones. Ken W. asks, will funding be limited to state agencies, or will organizations involved with operating an APC on behalf of a state agency be able to apply with the state supports? We don't know. But who knows, right? That's who will be eligible to apply on behalf of the state. We don't know. And then the next one here from Mike from Kentucky. For states that are interested in developing an APCD, what are the expectations of what ought to be done by the end of year 3 of the grant award? Again, no idea. I mean, if you say up front you're going to build this, you're going to have it done in 18 months or 2 years or whatever, and run into problems and don't make it to the end, do you have to give the money back? One would presume no, because they're investing in a development project. But again, it's a federal grant process, so we don't know. So those are the two easy ones that I saw. George, John, do you see any ones on there that you want to pick off?
Yeah, I would say that the voluntary language on the fully insured APCDs, at least again, it's a little tricky because for the states have the authority to mandate fully insured plans based on state authority. So I would see very little risk in any changes to that from this language. So I wouldn't worry. I mean, I shouldn't say I wouldn't worry. I wouldn't think a lot about that part for this. You know, I think how regional efforts, how voluntary efforts are impacted. I think that was on John's list, and I think that maintains itself as a question. But I think the notion of the voluntary language within the group health plan piece doesn't have impact outside of those ERISA plans. And in fact, that voluntary language exists in the ERISA language modification in the grant, in the legislation. And yeah, I think, again, this idea of how the grant money can be used, still a little unclear. And I would just say that across all of these questions, I do think that this advisory committee is incredibly important, because the advisory committee will be providing input across multiple domains, and it will be important to have supportive voices in that advisory committee, because these are the potential kinds of issues that you can provide guidance to labor and to Health and Human Services, to the areas that they're impacted on.
Yeah. So let's take about 3 more minutes on Q&A, and then we're going to switch over to discussion. John, did you want to focus on that first question from Jake Sundberg? Yeah, sure.
I'd be happy. I just want to make one more comment on what Joe said. I think it's also going to be very important. Many of the members of this committee are appointees from federal departments that probably know next to nothing about all payer claims databases and nothing about data formats for claims. And so it's going to be really important that we get some people in the other seats that have got some very strong technical chops. I'll just say that. Yes, so Jacob Sundberg, I appreciate your question. The short answer is that the data submission guides of different states, how similar are they? They're actually very similar. There is probably 85–90% overlap of common data elements across all the states, with really one prominent exception. But the vast majority of states are very much the same. We heard reference made to a common data layout that's been a multi-year effort that's almost culminated. But part of the problem here is, unless there is a real urgency to complete something, it's tough to complete something. And I think right now this labor process will be a way to complete it. I think it certainly makes a lot of sense that the common data layout that Joe alluded to earlier be a basis for the conversation there. And I'm sure that whatever comes out of this, I hope whatever comes out of this is going to rather closely resemble, the 90% of state data submission guides that highly overlap with one another. So technically speaking, this is not a difficult challenge. Politically speaking, this has been a challenge. And I think this is, again, an opportunity to overcome some of those political hurdles. So that's what I would say to you, Jacob.
Okay, so I want to spend the last 15 minutes of our time making sure that we issue a call to action to the participants. 257 participants from 48 states in the District of Columbia represented here today. If all we do is kind of rehash what's in the bill and kind of guess as to what it might look like, that's great, but it doesn't get us to where we need to be. And so from a group dynamic perspective, you have seen and heard from all three of us that there are important opportunities for input on key areas going forward. Nothing is decided. The secretaries have been nominated but haven't taken office yet, and certainly haven't been confirmed by the Senate. So there's a long way to go between where we are today and what this ultimately looks like. And I look down the attendee list. You who are on this call are the ones who need to have a voice. And I believe that we're going to be a lot more effective and we're going to get a lot better outcome if we work together than if we just send 250 possibly conflicting messages to bureaucrats who may not know exactly what we're trying to tell them. If we can filter and unify and get a broad-based support for specific provisions or ideas, we're going to be much more effective. So what can we do to make that happen? And then I want to have a discussion about some of this as well. NAHDO will continue to sponsor ongoing video conferences like we had today. We will let you know when those come up. I don't want to have them too often and then have nothing to just tell you, but this is on a fairly fast time frame, so expect them to happen on a fairly fast time frame. We've created a dedicated email address, apcd@nahdo.org, for you to filter information back to us. If you want to receive that information back out, again, use that same email address to let me know. I'm hesitant to just put everybody on some form of a group email address that you don't want to be on without your permission. That seems like that's not an ethical thing to do. But so if you want to receive information and feedback from us other than notifications of future meetings, I think that's fair game. But if you want to be part of a group conversation, let us know and we will add you to a group conversation. What we would ask is that you share information with others. So as you learn anything through your state contacts at CMS or SSI or wherever, as you learn something, send us that information. Don't assume that we already know. When GAO sent out their invitation for nominations, they didn't send it to everybody all at once. We were about 2 days behind in their process of getting stuff out. So we found out from one of our board members right off the bat. So we knew about it right away because somebody shared that information with us. And specifically, if you have any contacts at Labor or at HHS that you think will be helpful or involved, let us know. We would love to have you use those contacts to help us get our ideas moving forward. So with that, I'm going to ask John and Joe to each take a minute and give their thoughts, and then put stuff in the chat if there's something that anybody would like us to consider and think about how we can move together. I would love to hear about it. John and then Joe.
Sure. So this is, as I said, an unprecedented opportunity. The federal government is clearly standing up and taking notice of the need for state APCDs. There was a question in the chat we didn't directly address coming from Wade about what does this mean for a national APCD versus a state APCD. And I think this, in my opinion, again, very clearly leans it towards a state APCD. There was a separate bill introduced in the last Congress to try to push for national APCD that I think is now moot. I think what is a a good path, which I think is probably the most effective, will be that states get to generate their APCDs. They get support from the federal government to get up and running and make the improvements they need to do. We get a national standard that maybe is only for the ERISA plans, or maybe soon becomes the standard for all submissions, either de facto or by law. And then that becomes an avenue into sharing data back nationally, almost like an HCUP model of hospital discharge data sets, for those of you who are familiar with that. That said, this time is really critical. There's going to be a bunch of moving parts, and I think this is a critical time for folks who work in with state APCDs to stand up and be heard. And I think that this is a real opportunity for a role to be played by NAHDO and the APCD Council to really sort of be a convener of community opinion. So I really want to hear from those of you on the call as to how you feel that should play out, and how committed you are to following, if you will, sort of a federated model where states do this, and if so, a willingness or an interest in being part of a collaborative response and outreach to the federal agencies that are going to be running with this next.
Yeah, and I would add, I think we saw opportunities over the last 2 years or so to have input into, on this side, for what we saw, we had lots of opportunity for input into the legislative side, and now I think we've got the opportunity for input in the implementation side as this moves into both this grant program as well as this reporting format, and it's the foundation, I think, for good additional work and for sort of the ability to inform a lot of different agencies. I saw that that Stefan put in the notion about ASPE. ASPE has been very interested in state APCDs. They've funded a couple of reports around them. From a research perspective, I think it's the opportunity really for states to sort of shine in demonstrating the work that they've done to facilitate the collection of these data, and then a real opportunity to show and showcase how the states have used the data. So I think we've got a real opportunity, and I think it's really exciting. I think there's going to be a lot of work to do over the next 6 months or 8 months to ensure that the implementation of this is done in a way that's as beneficial to the state efforts as possible. And I think that's where there's sort of a call to action, as well as, not to put Norm on the spot, but I think there's a little bit of reserving the right to get all of you involved in some of the work that needs to happen in order to make sure that the federal agencies that are implementing really know the details about how this works on the ground, to ensure that we don't see sort of guidance come out that isn't possible for how it gets actually implemented. So I think it'll be exciting.
Yeah, we are definitely hopeful that many of you will be involved in providing input, keeping tabs, however you want to put that on this topic. We're really excited, and I maybe want to give a specific shout out. We've seen a lot of people register for this webinar or video conference who are from states where we haven't seen much action on APCDs. And we don't expect this to be the magic bullet that all of a sudden APCDs are just going to happen everywhere. But it is enough money to, at least I think in many cases, generate some interest and maybe some movement. And we would love to hear your plans for that. If you think that there are stakeholders in your state, or if you need to ask us questions about how to move forward, absolutely love to do that one. So Babette just asked a question here. Is our biggest concern, besides the consistency of data set across groups, is how groups like ours do not have direct contracts with providers decimated by disclosure of our rates to competitors. And so that goes back to this question about proprietary information. Clearly, there is clear language here that this process that the federal government is engaging in will not increase the amount or add new disclosure of contractual information. They've made great pains to lay that out in the language of the bill. I'm not entirely sure that that is as well defined as it needs to be, and will probably need to be worked out going forward. But I think what your biggest concern is not one that should be the biggest concern in this context, because it is very clear that that is to be protected. So we're hopeful that that will be well defined and taken care of. Yes, thank you, Kenley, for your offer of support. We've got about 5 minutes left. Are there any questions?
May I just ask for clarification? I know that I can read all the comments as a presenter. I don't know if everyone can read the responses, etc. So is that actually open to all participants to read as well as to write?
Yes, I believe so, because some of our attendees are responding to each other.
Okay, great.
So there's a question here from Brian Kegley. Does the state need to endorse the application? You know, one would assume that someone from the state government needs to say this is our state's APCD, but there's nothing in the bill that says how that's going to happen or what the level of requirement is going to be. So I've seen these big sort of spending things before where you need either legislative authorization or a letter from the governor. So either executive or legislative authorization. But one would presume that somebody needs to say, yes, this organization is in fact a state APCD and it represents our state.
Yeah, I think that's a key question, because we have, so what happens if you have a, either a voluntary collaborative APCD, or for that matter, a proprietary APCD in a state that applies for funding but is not legislatively established or officially established. The legislation is not clear, but I would come down where Norm does, that it seems that would be the way that it should be handled.
And I think I'm going to back up also on Mike's questions from Kentucky. What is the expectation? So I'm going to reframe that just a little bit. If you are a state that today has no legislation and nothing done, January of 2021, can you get it done in a 3-year period? And I'm going to say unequivocally yes. I don't know how long your legislative process takes, but assuming that it takes you no more than a year to get a bill passed in your legislature, you would have time to get an APCD enacted in legislation, up and running in that time frame. I think there's no question that 3 years plus, and apparently there is some lead time now between now and when the grant application is going to effect. So you do have time. Every state should be able to do this if you want to. If your state doesn't want to do it, well, then I guess the answer would be no. But if your state wants to do it, there's plenty of time.
I would agree. I'll second that. There are a couple of states, Colorado comes to mind, that got their APCD up and running, and not only up and running, but with public reports and transparency information in less than 18 months. It's an ambitious timetable, but it's been done and can be done. So I think that is an opportunity. Furthermore, that the monies that are appropriated do not need to be spent within the 3 years of those 3 fiscal years. Those monies are held over. So if it takes longer to expend the funds, this law authorizes that.
Yeah, and hopefully we would see that translate down to the grant allowances to do that too. That would be another one of these places to be sure that the federal agencies understand the need for those things. I think the other thing for folks to just be cognizant of is particularly for, as you're contemplating what this could potentially look like or what you might be interested in thinking about with these grant funds, is there were, and I think Norm had this in his slides, but there were 2 priority areas that were called out very specifically in the legislation, where the secretary had the ability to prioritize applications that had 2 dimensions, and the 2 were, if you are going to actively seek out the inclusion of self-funded data with the standardized format, and the other was if you had multi-state or regional looks at things. So I think Kyle put a question into the chat that sort of asked about the the interest in sort of collaborative approaches. I think those will be, at least according to the legislation, who knows what will happen when we move legislation into implementation of a grant program, but at least now it looks like those will have some priorities. So I think, again, as Norm said, leveraging this group to think about those sorts of collaborative projects would be a really good idea earlier rather than later, because there will be apparently some priority to those things.
Okay, and we don't know what priority means. When things are not competitive, it's hard to know what they're going to mean by prioritization. Does it just mean that they read yours first, or, I mean, but clearly there is an emphasis that those are things that Congress want to happen. So that's how I read that. If nothing else, you can read that Congress wants there to be multi-state, and they want states to use the standardized format for voluntary submission. Well, thank you, everyone. We are at the end of our hour. I do appreciate everyone's time, especially John and Joe, for joining me today and helping work through some of these issues. You have the email address, apcd@nahdo.org. Please feel free to kick us any additional questions over, and we will do our best. And we look forward to seeing you again in a very short time frame. Thank you, everyone.
Norm, before you go, just where do people, if they want to see the slides, just remind them where's the best place on the NAHDO website to find that?
Yeah, go to NAHDO.org, and then under the Resources tab, there's a No Surprises Act resources, and we put the slides right at the top of that page.
Very good. Thank you.
Thanks,
Thank
everybody.
you, everyone. All right, bye-bye.
Bye.